And I think that's the point of this whole contempt. It's not about the $1,000. It's about getting through to D.E.T.R that you're serious and the courts are serious. And this country works on a balance of powers, a separation of powers and a balance of powers. And you trump them all the time until you're appealed.
Whitney, please call the state's next witness.
Thank you, Your Honor. We would call Mr. Shane Ricketts.
Okay. We are going to break in about 10 or 15 minutes, regardless of where we are with Mr. Ricketts. Good afternoon, sir. Can you hear the court?
I can. Can you guys hear me?
I can. Do me a favor. Once you get a good area where we have a strong signal, do what you just did and put your smartphone down. All right. Thank you. Mr. Ricketts, I'm going to ask you to please raise your right hand, address my court clerk, and take the oath of witness.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. Ricketts. Please proceed, Mr. Whitney.
Thank you, Your Honor. Mr. Ricketts, can you please state and then spell your last name for the record?
Yeah, my name is Shane, last name Ricketts, Ricketts.
And Mr. Ricketts, where are you employed?
State of Nevada Employment Security Division, D.E.T.R.
How long have you been employed there?
Currently 9 months.
What is your current position with the Employment Security Division?
I'm the manager of the Benefit Payment Control Unit, or the Integrity Unit.
Now, prior to your current 9 months with D.E.T.R, did you work with D.E.T.R before then, or?
Yeah, so I was previously employed for 7.5 years, up until March 2017.
What capacity was that employment in? I'm sorry, what was your job then?
Yeah, so during that time, I worked at D.E.T.R and I worked for 2 years as an adjudicator, 2 years as a fraud investigator. 1 year I was a program specialist, and for the last 2 years, I was a business process analyst for the Benefit Payment Control Unit.
Now, in your current position, what are your main job duties and responsibilities?
I manage the unit that ensures the proper payment of the UI and P.U.A benefits, and also to detect and stop fraudulent claims and to create and collect overpayments according to the laws set forth by the U.S. Department of Labor.
Are you aware of the Ms. Amethyst Payne's court case with D.E.T.R in Washoe County?
I am.
And now, are you also somewhat familiar with the order of mandate in that case?
Yes, I am.
Now, have you seen Exhibit 17 before, State's Exhibit 17 that was created by Mr. Schmidt?
Yes, sir.
Now, are you able to tell us what IP Investigation Case Special Project BPC means?
Yeah, sure. Those are stops put on claims due to displaying known fraudulent hallmarks.
And can you tell us, was D.E.T.R pursuant to USDL guidance, were they supposed to pay on those claims?
Well, you're asking him for a legal conclusion, and he's not a lawyer, nor has he been designated an expert. I can tell you, you can ask him what his understanding is. You can ask him how he's been instructed, but that's not something that he has the ability to answer the court. That's really a legal conclusion.
Thank you, Your Honor.
Also, Ms. Clerk, I see that somebody named James G. has their hand raised. Do you see that?
I do, Your Honor.
All right. Well, right now, James G., if you're called to testify as a witness in this matter, or the court needs to hear from you, we will bring you on board. But right now, let me just hear from Mr. Ricketts. Mr. Ricketts. All right. Go ahead, Mr. Whitney, if you could please ask a different question.
Thank you, Your Honor. So why did D.E.T.R not, if you're looking at the first page of Exhibit 17, can you tell us why D.E.T.R did not begin to pay on those these claims again, the D.E.T.R for investigation case special project?
Yeah, because those fell within the allowable reasons to stop pay on claims from the court order mandate by displaying characteristics of clear and convincing fraud.
And so, just so we're clear, Mr. Ricketts, from Exhibit 17, it looks to the court like that's the second what you're testifying to are the investigation case special project bucket. The one above, though, that I thought the question referred to was other program eligibility. But, I'm going to state what I think is the obvious. The way you've been instructed to proceed is that if the individual is eligible for other UI or from Nevada or other states or similar programs, they're ineligible at this time for P.U.A. benefits. Am I understanding correctly the way you've been instructed?
Yes, that's correct.
All right. So I guess one question I have is, and I asked this earlier to Mr. Schmidt, like who actually told you that? Who directed you to do that, other than an attorney that's representing the state of Nevada? Was it a senior administrator? If so, who and when, please?
Yeah, I don't know a specific person. I know it was a collective decision made by administration that was passed down to my unit.
How was it passed down to your unit?
It really wasn't, I don't know. I mean, I don't have a specific email or didn't get a phone call or anything like that, but it was just known that was the process.
Okay, thank you. Mr. Whitney, please proceed.
Thank you, Your Honor. How about C.A.R.E.S, what does that mean?
So those are stops put on claims from June 15th forward due to an influx of fraudulent activity, and which we required claimants to upload identity documentation to establish their identity.
Why did, for those specific claims, why did D.E.T.R begin to pay those and then stop paying? For the claims that D.E.T.R did start to pay that fell into that category, why did D.E.T.R start paying them and then stop paying them?
Because the claimants didn't upload the required documentation as instructed, and at the time with the high influx of fraudulent claims, it indicated that it was a fraudulent filing.
Did D.E.T.R consider the fraudulent filing to the extent, going to the extent of clear and convincing evidence with the C.A.R.E.S?
Yes, on the ones that received a disqualification.
Can you tell us what two-factor authentication bad phone means?
Sure. This is an anti-fraud stop built into the P.U.A. system, and it requires additional authentication upon login to the claim. The user logs in, and then they're prompted and sent a code to the cellular phone number that they have provided. And if the code is sent and then rejected, the system puts this issue on a claim due to the phone number provided not being valid.
So did D.E.T.R also, so then what specifically were these claims stopped for, the two-factor authentication, because the person didn't respond with the correct code, or?
No, they did not provide a valid phone number. So whenever the system sent out the authentication message, the phone number was no good.
The phone number being no good, did D.E.T.R consider that evidence of fraud?
Yes, and also coupled with the other hallmarks on the claims, as well as the claimants were also provided another opportunity to unlock their claim if they did get caught up in this two-factor authentication bad phone. So there are multiple ways the claimants could have cleared this up and resolved the issue themselves.
Now, was it your understanding with respect to the investigation case special project, C.A.R.E.S, the two-factor authentication, is it your understanding that D.E.T.R was not supposed to pay on those claims?
Yeah, because there are signs of clear-cut fraud.
there's another category for staff review. Are you able to tell us what that means?
Yeah, give me 1 second.
Well, the way it's identified in the exhibit, Mr. Ricketts, is staff review code 749 issue generated when system detects potential UI eligibility at court or change. So is it what it suggests, that payments were stopped because
Yep.
somebody now might be eligible for UI?
Yeah, correct. It means that the claimant was eligible for P.U.A, but subsequently earned sufficient wages at quarter change to qualify for the traditional UI program.
Okay, you are breaking up just a little bit, but I got most of that. Okay, Mr. Whitney, I think I've got most of what you wanted me to hear from Mr. Ricketts. Again, keeping in mind at 4:30, I'm going to hear argument. We are taking a 15-minute break shortly. That leaves us about another hour to finish Mr. Ricketts and to hear from any other witness the state wants the court to hear from.
Thank you, Your Honor. I'll probably be wrapping up fairly soon with Mr. Ricketts, I think.
Okay, go right ahead.
Oh, thank you. Are you aware of Mr. Ricketts? Are you aware of UPL 1620?
Yes, sir.
And does that UPL require the state to take reasonable precautions to detect and deter fraud?
Yes, sir. It specifically says the states are required to take reasonable customary precautions to deter and detect fraud.
What does IP identity theft mean?
So this means that somebody's personal identifying information used to file a claim was done by someone other than the true owner of the personal identifying information.
Would D.E.T.R consider any claimants that fell into that category as having hallmarks of fraud? I'm sorry, any claims within that category of having hallmarks of fraud?
Yes, definitely. And NRS 612.445 says specifically that as well, that filing a claim for benefits using social security number, name, or the personal identifying information of another is fraud.
Yeah, I mean, it's not just civilly wrong, it's a crime, as the
Exactly.
court understands it. So, but that's, Mr. Whitney, as you saw, that's only one person. So that's not where the decision of the court here is not going to fall on either side of that one. The two biggest issues of the 33,000 people, give or take, the two biggest reasons are that there is hallmarks of fraud. And I know the plaintiffs believe that that is not enough, a hallmark versus clear and convincing, or they're concerned that the state hasn't given the person an opportunity to respond to the state's concerns based on the hallmark. So that's 10,000 people right there of the 33. And then the other 10,000, the other big group, are those that the state is not paying because they believe the person is now or has recently become eligible for other benefits. That's where the rubber hits the road, primarily for purposes of the hearing today. Those are the two largest buckets, unless I'm misunderstanding the evidence, but I don't think the court is.
Mr. Ricketts, counsel in substance had questioned you about with respect to some of the people that the D.E.T.R had thought there was indicia of clear and concise indicia to determine there was a fraudulent claim, that virtually none of those people had been interviewed. Were there attempts, and I hope I'm characterizing that right, did D.E.T.R attempt to contact these people to speak with them personally?
Yes, and as mentioned earlier in previous testimony, we did send them a message to their message box in the P.U.A platform, as well as we sent out the blast. Also, we would have, if we saw that they did not get that message, then we would have called and left them a 48-hour message.
There was also a question about checks. And I know the issuing of checks by D.E.T.R. And I believe you'd answered, you thought that one of the reasons was cost. Do you know of any other reasons that checks may not be issued by D.E.T.R?
It would be, it would be a lot of work, and another thing, it would delay payments even further. And so I believe that the direct deposit and the debit cards are the most efficient way to issue payments.
Thank you, Mr. Ricketts.
Sure.
So, Mr. Whitney, please, let's wrap up Mr. Ricketts so we can move on.
Your Honor, I think I've asked all the questions I would like to ask of Mr. Ricketts.
You followed the court's cue very well. Ms. Jones, examination of Mr. Ricketts.
I'll be quick, Your Honor. Mr. Ricketts, you said that you were a fraud investigator for 2 years. What years were you? Like 2002 to 2004?
No, I would say it was, well, I guess 5 years. So yeah, roughly around 2010, 11.
So that was pre-C.A.R.E.S Act, pre-COVID. What was the percentage of fraud that you saw in the U.I. system pre-COVID?
It was, prior to me coming back in the years that I wasn't with the state, it was very low. Prior to that, during the, I guess, the economic crash, it bumped up pretty high to around 50% at one point, I would say was the high.
50% of the people that applied were fraudulent?
Correct. At one point, not throughout the whole.
So, and is that, they were determined fraudulent after a hearing, or just they had indices of fraud?
It was clear and convincing.
That wasn't my question. Were they given an opportunity to be heard, and 50% of the people that were given an opportunity to be heard were 50% fraudulent? Is that what you're saying?
I would say not over the entire time frame I was an investigator, but that was the high. And those people were basically claims that were filed and victims of identity theft. And so they're, if somebody's stolen identity and you try to reach out to hear them, they're not going to respond.
Okay. What percentage of IP investigations result in the fraud determination?
There is no fraud determination.
So you don't actually make a determination. You just say, oh, there's these indices, and then it goes on to a different department? No,
we detect suspicious activities that gives us the clear and concise evidence that we need to determine that it's a fraudulent claim. And then a lot of the times those are denied with the 746 determination, because right now our rules say that in order to classify a determination as fraud, you have to speak with the claimant.
So the numbers that are provided in Exhibit 17, none of these people have actually been spoken to. Is that correct?
It just depends. I wouldn't know without looking on a case-by-case basis. There are different types of fraud.
Okay. Why doesn't D.E.T.R issue checks? In your experience as an adjudicator and a fraud investigator, why don't you just issue a check, and then if a person goes and cashes it, it's on the bank?
I believe due to cost reasons.
Due to cost reasons. Is that what
Correct.
You said?
Yeah.
Doesn't it seem to you, as in your personal opinion as an adjudicator and fraud investigator, that that'd be a pretty fine way to keep people from getting fraudulent UI benefits?
Well, that's argumentative because let's talk about what's really happening here.
Okay.
Here's what I'm understanding. Of the roughly 8,200 people whose payments began but have stopped because of concerns that there are hallmarks of fraud, approaching or at the level of clear and convincing evidence. Not just some, not just many, not just most, but virtually all have not had essentially a personal interview or direct personal interaction with somebody at the Employment Security Division. It's just not how it's working right now. It's not feasible. It's not, there might be a couple or a handful or some outliers, but what I'm getting, Mr. Ricketts, both from your testimony and from others, that's just not what's happening right now because there's no formal determination which would otherwise require that type of in-person interaction or direct person interaction. So, but if I'm wrong, please straighten the court out. But if I'm right, so you can confirm the court's understanding.
You're correct, Your Honor.
All right. So, Ms. Jones, when you summarize here in an hour, you can argue to the court what that means for purposes of this motion, but let's not argue with Mr. Ricketts whether it's a good or a bad idea, how things are going. So, or whether checks are preferable to direct deposit or, prepaid cards or anything like that.
Thank you, Your Honor.
Welcome.
I have no further questions.
All right. Mr. Ricketts, with the court's thanks, you can exit this hearing. Thank you for your testimony. Thank you for your work you're doing. On behalf of the state, to you and your family, a safe and healthy holiday. Counsel will be in recess until 3:30. Please have Mr. Whitney, the state's next witness, lined up, and the next one after him or her. How many more witnesses do you have, Mr. Whitney?
Your Honor, Mr. Ricketts was our last witness.
Mr. Whitney was your last witness?
Mr. Ricketts was, yes.
Excuse me, Mr. Ricketts was the last witness. All right. You don't want the court to hear from the director?
Your Honor, she was not listed as a witness on our witness list.
All right. Well, I mean, if you don't want me to, or she's not ready to go,
She's actually listed as witness number 5.
Oh.
And we would also just briefly object to having Director Cafferata called as a witness. She was not listed on plaintiff's witness list. She was listed.
She doesn't have to be. If you list her, the court understands she can be called by the plaintiffs in rebuttal to evidence that the state has presented here. So I'm going to allow it. Now, she's not under subpoena. She's here as the client representative. I can't compel her to testify if she refuses to. But this matter would be continued, and I would allow the plaintiffs to effectuate a subpoena on her and then have her testify anyway. So that's the way I'm going to approach it. They have a right. You listed her on their witness list, so they have a right to expect that she might be called as a witness.
Potential witness list, Your Honor. Actually, I don't know if we ever. I don't think we actually called it an actual. I think we've always titled it potential witness.
Well, I mean, each side filed. Let's not split hairs here. Each side filed their list of witnesses, list of potential witnesses, list of expected witnesses to give the other side a heads up of who would be called to testify in this matter. And she was on yours. So, I exercising the court's discretion to have a full and fair hearing to allow limited examination and rebuttal from Ms. Cafferata. Now, if you say, Your Honor, that would be abject unfairness. We would need time to prepare. But I would generally not agree with that. I would frown on that. I would like to hear from her and get this hearing over, have the court make a decision. But I'll give you a moment off the record, Mr. Whitney, Mr. Ott, and Ms. Cafferata to discuss this outside the presence of this hearing. Come back on in about 10 minutes and tell me your position, if you'd like that, Mr. Whitney.
Please, that'd be great. Thank you.
All right. We will be in recess until 3:50. And then again, Ms. Jones, you can identify on the record why you believe you have a right to call her at a hearing like this. So we'll be on back at approximately 3:50. We'll be in recess until that time.
Thank you.
Thank you.
the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Best interest is not, can you give her a pony?
Ask the question, make sure we're being accurate with what the document means.
Overruled. Let's just get through this. I want to know what the facts are.
To find out what the facts were. I agree, the record's a mess.
We're on the record. We took a short recess. Went back just to review NRS 50 on witnesses. As we all know, generally NRS 50.165 sub 1 requires witnesses validly subpoenaed to appear for court. But sub 2, of course, says a person present in court or before a judicial officer may be required to testify in the same manner as if the person were in attendance upon a subpoena issued by such court or officer. So, the court has authority to order Ms. Cafferata to respond to questions. Of course, she would not be called by the plaintiff in their case in chief. It would be limited to rebuttal. But of course, the court has discretion if it finds there's fundamental unfairness under the circumstances to either decline to allow examination or to continue this to a later time, likely next week or tomorrow morning to finish this hearing. Anyway, that's the court's thought process. Mr. Whitney or Mr. Ott, what would be your position on behalf of the state?
Your Honor, we are prepared to have Director Cafferata call as a rebuttal witness by plaintiffs.
You're going to have to talk up just a little bit. My ears don't work that well.
Sorry, Your Honor.
That's all right.
We are, Judge Cafferata is available to proceed right now as a witness.
Very good. Thank you very much. All right. So before I have her sworn in, Ms. Jones, anything else you'd like to put on the record?
No, thank you, Your Honor.
All right. And again, the testimony will be limited to rebuttal, which is areas that were brought up by the state in its case in chief. And without further ado, Ms. Cafferata, if you would please unmute yourself and address my court clerk, raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, Ms. Cafferata. Can you hear the court all right?
I can.
All right, thank you very much. Ms. Jones, you may proceed.
Thank you. I appreciate you being willing to testify. I only have a few questions. We've heard today throughout testimony from various D.E.T.R employees that the directives regarding the start-stop payment people came from the administration. Do you know who they mean when they say from the administration?
I'm so used to testifying in front of legislative committees. I want to identify myself. Sorry about that.
As you know, I started with D.E.T.R on August 6th. So I do not have firsthand knowledge of who made those decisions or what they mean by that.
Were you aware of Miss former Director Gah's decision not to pay the stop people?
Again, the Administrator Gah was the ESD administrator at the time of the court order. And the decisions that were made, I think, have been accurately characterized. At least what the staff have testified to is my understanding of the decision that was made. And the administrator has the legal decision-making authority in this particular case. So that was how it was characterized to me, is what they have said.
So are you ratifying Administrator Gah's decision?
Well, I'm going to object at this point. This is kind of moving beyond rebuttal, it seems like.
Well, I don't think it's goes beyond, because the court asked, and each of the witnesses responded with respect to, who decided to withhold payments in light of their view of what the court's order required. And so questions along this line are permissible and don't go beyond the scope of permissible rebuttal. Ratify, though, is a little bit of a legal term. I guess, Ms. Cafferata, what I want to know is, when you took over as administrator, did you have the opportunity to look at decisions that were made before you by Administrator Gah and the right to correct, challenge, revise, edit, or modify?
Your Honor, so I guess I would describe it this way. In the state law, the ESD administrator has certain legal authority over the employment security program. The director of D.E.T.R, or at the time I was the acting director, does not have that legal authority. The legal authority rests with the administrator. So it is not in my job description to revise or review or revisit decisions of the administrator, because she has the legal authority. She has the legal the ramifications of the legal decisions that she makes.
Fair enough. Who's the administrator now?
We have a brand new administrator. We've been in a little bit of an interesting situation, because Kimberly Gah is no longer the administrator. Her last day was actually October 9th, I believe. We had a contract acting ESD administrator who couldn't have the legal authority because he was acting in a contract position, and under state law, contractors can't have certain statutory authority. Linda Parvin is the new ESD administrator. I believe she's been the ESD administrator for 3 weeks. So Your Honor, what I would add that I don't think we have had the chance to sort of really explain is that I was involved in many, many conversations about how can D.E.T.R comply with your order. And staff would come to me with recommendations and programs and ideas for ways we could go through the P.U.A claimants, given the limitations of what the program did with our vendor, which, as you know, we built in modules. And we always pursued every program, every search. We assigned groups of claimants to specific teams, the welfare workers, our best adjudicators, and went through the list in every way we possibly could to find the folks who might have had a payment start and then stop and get their cases resolved. or get them into payment status. And I was involved in all of those decisions, and always was directing the staff to do everything we could to comply with your order.
Thank you. I may have some more questions. Ms. Jones, you may proceed.
Your Honor, that's really all I had for her. Trying to find out where the buck stops.
Thank you, Ms. Cafferata. Did you have any discussions directly with Ms. Gaw when she was administrator, or in any group session in which Ms. Gaw was acting administrator, other than in the presence of counsel, where she relayed to you her view of how to interpret the court's order on to reinitiate payments to those 4 categories of people that are identified in the order of mandate?
We had several discussions about complying with the court order.
All right. Did any of those discussions center on you've heard me use the word today, the tension between the court's order on the one hand and the guidance from the Department of Labor and the way the state appears to be construing that, to the effect that if somebody has eligible benefits under state of Nevada or other states' programs for unemployment or similar, then they're not eligible at that time for P.U.A. Were you involved in any discussions with Ms. Gaw about that, or in group discussions in which she was a participant?
Yes, I believe we discussed the challenges of complying with the order and following DOL guidance many times. And as I indicated, try to come up with every possible approach we could to meeting both tests. Okay, but why was it so hard? In other words, why not just follow the court's order and pay those people that had, again, the court order did not direct the state to begin to pay somebody who the state believed was otherwise ineligible. It didn't direct the state to pay people who had available an UI account that might apply, or could receive benefits out of state for UI benefits. These are people for whom payments began, and that's a narrow subset. And the court already reviewed in advance of its order in July. It already reviewed the governing law thoroughly, which admittedly is nuanced, is evolving, is complex, particularly to translate that into pandemic unemployment assistance program and payments, which heretofore didn't exist, in light of some of the structural limitations that the Employment Security Division was facing, and the well-known fact that Nevada, in particular Southern Nevada, is essentially ground zero for the economic effect of the pandemic in the United States. But the court considered all that. And at the end of the day, the court's order was pretty clear. In fact, the court's order was more than pretty clear. The court's order, as I intended it, was completely clear. It didn't say to not pay if the guidance from the Department of Labor was viewed contradictory. It didn't say to not pay if there were efforts used to try to find a way, an algorithm, an approach that would allow both goals to be served. It didn't have those type of limitations. In the court's mind was clear, unambiguous, and meant to be followed. And one of the reasons that this hearing did not occur earlier since the deadline expired, I believe, was the sense by the plaintiffs that good faith efforts to comply were ongoing. In fact, it's not lost on the court that even the special master, Mr. Guanasso, in the second of his major pieces of work, opined at the end that the state was substantially complying at that time with the court's order, although he noted several ways that it could improve the approach. But at the end of the day, his conclusion, of course not binding yet informative to the court, was that D.E.T.R was in substantial compliance. And that
likely bought some time for the state to avoid this type of a hearing. Yet here we are. And so it's a bit distressing to the court to see that on Exhibit 17 in particular, there are 9,841 people that had their payments begin and then stop with the state's rationale that those individuals may be eligible for regular UI, PEUC, or SEB in any state. In fact, we heard from Ms. Boyd, Mr. Kozulnik, and Mr. Dougherty. Excuse me. And that doesn't apply to Ms. Boyd. But as to the other two gentlemen, it seems to the court that at best, there might be concerns by the state that they would slot into that group. Anyway, with all that as background, Ms. Cafferata, in any of the meetings you had with the administrator or any discussions with her or in her presence, why at the end of the day did that view trump the court order to the best of your understanding? Unless you think it didn't trump it, unless you think it's still fluid.
Your Honor, I would answer with two things. One is the maybe three things. The cases that we have heard today, I believe, reasonable people might disagree, but we have fairly clear guidance that if you, within one application, have contradictory statements or misrepresentations, or in the case of P.U.A, you must have a COVID reason for your unemployment, and you have to certify that every week. If you don't do that, but you try and apply, that's clear and convincing evidence of fraud. Fraud determinations are a whole separate process. I think we've sort of made that clear. So I would argue that, first of all, we felt that the people who got a payment and then stopped getting payments fell into one of the buckets. I would also say that the other thing that we haven't talked about is several of the UPLs, as we call them, UIPLs, that have came out subsequent to your order. We have had more UIPLs this year than probably in the 20 years prior to this year. And that is because
let's make sure for people watching at home, let's sorry to interrupt. Let's make sure for everyone watching this hearing, we know what your definition of UPL is. What is that definition? Or
unemployment insurance policy
letter.
Okay, thank you.
What's the last word, Ms. Jones?
Letter.
Actually, Your Honor, I think it's the P stands for, and Attorney Jones, I think the P stands for program.
This is
okay, but in any event, there's been more guidance that's been received, is what you're suggesting, right?
There's been more guidance from the Department of Labor on a very regular basis, and in several circumstances, and I would have to ask my attorneys to give you the citations. However, in several cases, the Department of Labor has very clearly said that if someone is in the P.U.A program and they have other program eligibility, most of the time regular unemployment benefits, either in Nevada or another state, we are to stop their payment and move them to regular unemployment. Specifically, the case that certainly when the order was issued, I know we were all hoping would be able to resolve all of these cases long before the next quarter change. But the guidance from the Department of Labor is exceedingly clear that we have to reevaluate all these claims at a quarter change to see if they have eligibility in another program. And so I think your order is quite clear. And we continued to get guidance from the Department of Labor that was also quite clear. And so my sort of decision-making compass was, how do we best work through these programs, do our work in a way that meets the spirit of what you were trying to accomplish, which is get people the payments that they are eligible for. And if you look at Mr. Dougherty's case, if we had paid him in P.U.A. in Nevada, he would have ended up with a $17,000 overpayment because he had clear eligibility in another state. And at this point, without Congress acting to extend the benefits in regular UI actually last longer than the benefits in P.U.A., which will end the week of December 26th. And so that has always been sort of my guiding principle, is to balance these two and the best we can get these people the payments that they deserve in a way that will not also harm them.
Okay, just to make sure that anyone listening to this didn't just fall out of their chair when you indicated the payments would end, the last week of December. The claims will continue to be processed well into 2021, and people that otherwise were eligible for benefits they'll be paid in arrears, paid what they're owed up to that point in time. That doesn't mean that they won't hear anything from the Employment Security Division after that. That just means the money allocated by Congress runs out, but it still will be available to them next year if benefits were owed for this year. Is that fair?
Yes, that's correct.
All right, good.
I don't know where you get that from, Your Honor. Who knows what they're going to do up there? Mr.
Well, hasn't the, let's,
No,
I mean, I don't want
he's
to.
doing a clawback right now. The Secretary of the Treasury is doing a clawback. He wants that money back in the Treasury. He
Okay,
doesn't
well,
want it to go out.
I don't want to get the train too far afield, and that was the court's fault for bringing that issue up. But the way the court understands it is the money doesn't all have to be paid for P.U.A. The claims have to be in process. All right, but we're not here to decide that. We're here to decide whether the state has complied with the court's order, and if not, what the corrective action is. Hold on. It's not open mic just yet. Ms. Cafferata, I appreciate the response to the court's questions and concerns. I don't have any additional questions at this time, but before I thank and excuse you from the testifying, let me ask Mr. Whitney, do you have any questions of Ms. Cafferata?
Thank you, Your Honor. I do not.
Thank you. Ms. Jones, any questions in light of the court's questions and Ms. Cafferata's responses?
I don't have any questions, but I will defer to Mr. Thierman.
No questions.
All right, thank you very much, Ms. Cafferata. Thank you. And I hope you stay on the call and the hearing and observe the remainder of the hearing. All right, that will conclude the evidence at this point. At this time, I ask each side to summarize where they are, what they're asking the court to do, what you believe the evidence showed, and why the court should proceed in the manner you're suggesting. Let's start with the party that has the burden of convincing the court that the state has violated the court's order, that being plaintiff, either Mr. Thierman or Ms. Jones. You may proceed.
What? All right, let me take a stab at it. You've identified it pretty much in your questioning. There are 22,000 people approximately who were in that group, that protected group, covered by your order. And despite what Ms. Cafferata says, there is no clear statement that you're supposed to stop. Every single UIPL says we defer to Java, don't forget Java, don't forget Java, but then it goes on. And it doesn't say stop, it says they're not entitled to benefits. And that's different than stopping. Second of all, because that's initial claims. Second of all, as your Honor heard, they're supposedly processing 700 claims a day. Well, there are only 22,000 people here at 700 claims a day. That's 50 days, 40 days. We're 9 months later or 6 months later from when your order was, 5 months later from when your order was. They aren't processing anything. They're not sending out any notices. They're pinging phones, and I don't know how many people there didn't respond. But you know, they're not processing it with the idea of paying people. They're processing it with the idea of, we're going to cull through this bunch of thieves, 50% or more, and we're going to take a few good ones out and pay them randomly. That's not what the process is about. That's not what your order said. This is a question not only of P.U.A. versus U.I. This is a question of separation of powers. This court issued an order. This court issued a directive. And if nothing else, they should have come in and said, you know, Your Honor, we're going to take an immediate appeal. We want a temporary stay. You're so far off that we're going to lose our benefits, or we're going to lose this stuff. Unlike Oregon, who, by the way, pays in the middle, and they didn't lose anything. Unlike the Department of Labor just came out with a report saying that most states underpay the minimum just to get it off their books first, and then they go back and adjudicate the difference. But instead, they just decide, we're not going to pay your order. We're going to try to blend your order into the bunch of other stuff that's all over the place, from pre-COVID to post-COVID. They didn't follow your order. And that's separation of powers. It goes back to Mulway versus Madison, frankly. This court issues an order. If they don't like it, they can either disobey it and take a contempt, or they can come in and ask for modification and take an appeal. And they didn't do that. And they didn't do that maybe because of the changeover, maybe because they keep looking at this thing the wrong way. We've been arguing that. We're going to argue it again in the Supreme Court as somehow not an entitlement, but some gift that they have to dole out instead of the other way around. But we know 22,000 people were given their benefits, so there's no question that at least somebody made an initial determination they were eligible. And that's what JABA was. That's the heartland of JABA. They were given benefits, and then they were taken away. You can't do that. That's Goldberg versus Kelly. That's all the administrative law cases from the 1970s on forward. It's administratively inconvenient, right? And there is a percentage of people who will never be able to pay it back. And if you look at the Jenkins case out of the Seventh Circuit, they said, well, people who are convicted or people who are being held in custody, arrested for crimes against their employer, which obviously is grounds for disqualification of unemployment benefits, can't be blanketed, not paid until the courts decide whether or not they're guilty. And same thing here. You cannot have these prophylactic, you're guilty till proven innocent, broad brush rules. They just ignored your order. It's that simple. And you know, the $1,000 is going to put a whole lot of bread on the table. I would like to see the $1,000 per person. And there's nothing in the statute that says you can't do it. And I couldn't find a case one way or the other. Ms. Jones is much more conservative than I am. But that's not even the point either. The point is, pay these people and pay as many of them as you can. And DOL is not going to come and yank your license away because you followed the district court order. And if DOL has a problem with it, let DOL take the appeal. It's not happening. It's just a bunch of fraud in the horizon. You know, I mean, some of their denial letters say you're being suspected of. What is this, McCarthyism? Being suspected of. Clear and convincing evidence is a lot more than indicia of fraud. Clear and convincing evidence is somebody either has, you know, irrebuttable or almost a highly unlikely that it's not. And what do they have? Oh, someone's phone is, you know, has a 415 area code. Oh, gee. Someone else has a VPN and he's pinging out of South Africa. We know scientifically that IP addresses are not an accurate indication of where people are located. And it doesn't matter where they're located when they apply. It only matters where they were located when they stopped working. So, I mean, all these excuses, all these reasons is the same old. They didn't take your order seriously. They didn't change their behavior. And what we got is Ms. Cafferata saying, well, I didn't exactly ratify it, but yeah, I agreed with it. Well, that's ratification. And if they really want to change things, then blame it on you, blame it on the courts, but change them. And I think that's the point of this whole contempt. It's not about the $1,000. It's about getting through to D.E.T.R that you're serious. And the courts are serious. And this country works on a balance of powers, a separation of powers and a balance of powers. And you trump them all the time until you're appealed. And that's the closing. It's not about the $1,000. It's about the principle of the thing. And 22,000 people is a lot of principles.
All right, thank you. Let me, before I hear from the state, let me clarify two things. One is you have filed two separate motions for orders of contempt. Now, it seems to the court you're pursuing the second one. Am I wrong?
No,
or am I right?
You're correct.
All right. Second, you've asked the court to take judicial notice of an amicus brief filed with the Nevada Supreme Court by Nevada Legal Services. Now, in what way would the court take judicial notice? I mean, I can take notice of other court filings or other public records, but it's not a factual assertion, and it's not a legal point of law. It's argument. So how do I take judicial notice of that?
Except for the incidents of fraud that they report as 6.5% at the maximum, which is less than 10% when the Secretary of Labor testified that he expected at the time this program was passed. But they rely on information unique to them. The court has no barometer as to the accuracy. It's not subject to challenge or cross-examination. Okay, so how many instances of conviction or fraud have they come in here with? How many of the 22,000 people got a determination, much less a conviction? How many people even had a hearing? None. Okay. You can't have fraud without at least, it's been 5 months or 4 months since you issued the order. At least you should have a hearing. There's no written letter saying, oh, by the way, we think you have fraud here, clear and convincing. There's nothing. It's just like, oh, okay, I think there's an indication of fraud. We'll put that aside. You're not going to get paid for a year. These people are starving. I can't do that to them. This is in the Cuomo case in New York. This is subsistence. This is per se irreparable harm.
All right. Before the court would take judicial notice, the state would have an opportunity to be heard. However, the court declines to take judicial notice of the filing of the Nevada Legal Services, so I don't need to hear from the state. Now, did I skim it just to see what it was and how it might relate? I did, but because I will not consider it, it will not be used by the court for purposes of this hearing. I need not hear from the state at this time. All right. Who will argue for the state and against a order finding the state in contempt, Mr. Whitney or Mr. Ott?
Your Honor, I will be handling.
All right. Thank you. Please proceed.
Thank you, Your Honor. I'll try and be brief. I'm sure the court was aware of Special Master Guanasso, the independent party, back in August with his final special master report, did find that D.E.T.R was in substantial compliance, page 111 of his report. I'm sure the court remembers that. Your Honor, we submit that D.E.T.R is in substantial compliance with your court order. We've heard from Director Cafferata that there's and the court's picked up and noticed too and pointed out there is a tension between the court's order and what the U.S. Department of Labor requires. Now, the court has said that you don't intend for the state not to violate any guidance of U.S. DOL. And but Your Honor, there UPL 1620, the way D.E.T.R reads it, and also it's backed up by the fact that when there's a quarter change, there's a check for eligibility for P.U.A applicants to see if they're become eligible for another program. The evidence is there that if someone become a P.U.A applicant that's being paid P.U.A, I'm sorry, P.U.A claimant being paid P.U.A, if they become eligible for another program, say for example at a quarter change, then the P.U.A benefits are stopped. That is guidance from from the U-Poll. So there's that tension there between trying to comply with the guidance which the state, ESD, as on behalf of the state, said it would agree to follow back when the agreement for P.U.A funding was signed back in late March. There was a discussion about the second largest category behind people that were not paid. I'm sorry, the people that had eligibility in the three other programs. The discussion about those people, and we heard Mr. Ricketts and testify about indicia of fraud there, and the notice that's actually sent out to people. One thing that I like to point out is he did point out that these people, at least D.E.T.R made an attempt to contact them. Now, maybe many of these people weren't spoken to, but it's really a two-way street. There's information that's sent out to these people for D.E.T.R to try and contact them to get more information. And if you are somebody committing fraud, then you're not going to respond to that. So that these denials seem to, if D.E.T.R attempts to contact them, then there's these indicias of fraud. Denying them seems to make sense rather than paying somebody that don't know perhaps their identity, if this is even a real person. We've heard testimony from Mr. Bracken discussing the shape D.E.T.R was in back in late July, in that time period. And it seems clear that there just really wasn't any feasible way that D.E.T.R could, short of violating the U.S. Department of Labor clear regulations about just paying everybody. I believe that was my understanding of the blanket statement that Mr. Bracken had mentioned. It seems clear that there, with such a short staff, a small staff handling and processing these claims, this was not something that was going to happen within the 1 week that the court gave D.E.T.R to get into compliance. Mr. Bracken couldn't remember this total universe of claims at that time, but 16 people, and they were processing 500 to 700 claims per day. Just was not going to cut it. We heard from Mr. Schmidt about the fact that many of these people that were in charge of D.E.T.R, in the time, just before the time of the court's order of mandate, they've been gone for quite a while now. We've heard testimony from Director Cafferata that Administrator Ga apparently was the last person named in the complaint. She's been gone since almost 2 months now. Deputy Director P.U.A, Mr. Schmidt testified, I can't remember the date, sometime around the time of the court's order of mandate, maybe before, maybe a little bit after. And then Director Korbulak was gone before then. So it asked the court to consider, the fairness of imposing contempt, finding of contempt on people that frankly haven't been in charge of the Employment Security Division for some time now. And also from what Director Cafferata said, the amount of authority that the administrator does have versus the, at that time, Deputy Director P.U.A and Director Korbulak. We've seen the 3 witnesses that were brought forward by plaintiff, and it's clear that they felt like they should be paid, and it sounds like their testimony, there's some feelings there that that they weren't clear about why they weren't being paid. But we've also heard the explanation from Ms. Allender. We have somebody that is self-certifying on their claim that their employment has in substance been affected by the COVID-19 pandemic. Yet one of the people had certified that she hadn't worked since April 2019, well before the pandemic. The two other gentlemen, the two other claimants that testified, again, it appears that they initially had eligibility in P.U.A. and then became eligible in U.I. And that again is D.E.T.R is asserting and submitting that pursuant to U.S. dual guidance, the P.U.A. program, which is a new program, I'm sure the court recognizes. Guidance says that those payments are to stop if somebody becomes eligible for another benefits program, UI, state extended benefits. And just really briefly, Your Honor, again, this was something that wasn't brought up too much today, but it was in, we did put it in our response brief. I can't remember what it's titled. I'm sorry, I'm a little bit tired right now, but again, that the writ needed to be personally served in this case, and it was not personally served. Notice, I'm sure the court recognizes it's not the same as personal service, and electronic service is not personal service. So based on all the circumstances, Your Honor, we'd ask that you deny plaintiff's motion for contempt. And thank you.
Thank you. All right, Mr. Thierman, a brief reply, and then the court will issue a decision. And if you'd like, address, among other things, the state's position that there were service issues here that the court ought to take into consideration.
I said, I don't know if there was service issue. I don't know when this statute was passed, there wasn't electronic service. But they all had notice of it, and they all had an opportunity to correct it. And the fact is that I don't even know where you would find, am I going to go to Mrs. Cafferata's house? I don't want to go to her house. I don't want to serve her in the middle of the night. That's not what we're here for. We're here for getting people paid. And, if you don't have this tool, I don't know what tool you have to force them to do what they're supposed to do. Miss Allen there says that she thought they handled it poorly, that there was no true fraud, and they should tell people. I mean, you get a letter from D.E.T.R saying you're not eligible for P.U.A. Contact D.E.T.R for UI. You got the letter from D.E.T.R. I mean, talk about confusing. But that's not even the issue. The issue is, did they follow the order? They didn't. D.E.T.R was served. D.E.T.R knows. It's their attorneys were served. They know. D.E.T.R is an organization. D.E.T.R needs to fix it. I'm not saying Ms. Cafferata's heart isn't the right place, but someone's got to reorder D.E.T.R's priorities. They have to pay these people because you ordered it. And again, nobody sent anybody a letter. They said, oh, we tried to call them. I mean, I don't know how many times you hear that excuse, right? Oh, I tried to call them. Didn't even leave a message. Nobody followed up with a letter. No one said, hey, unless you get back to us in 48 hours, the U.S. Postal Service still works. Unless you get back to us in 48 hours, we're going to have a hearing immediately without you. I mean, and they send them the wrong information on the hearing, by the way. Under P.U.A, it's 60 days to appeal. 30 days they have to issue a decision. And that's in 20 CFR 610A, first sentence. And so they're sending out misinformation. And then people who are lay people are supposed to guess. They're the ones who have the burden of showing that once benefits begin, that they have a reason to stop. And you can't put in the trigger mechanism, that is filing an appeal, if they don't give you a written notice or something to appeal from. And they don't give you a written notice. And the appeal button after July 28th and worked half the time and not half, it doesn't work for some people because they're in process. I mean, you saw the screenshots. In process means you can't appeal. So they didn't say to them, oh, you're being denied because of fraud. You're in process. Well, they can't appeal it. You can't do anything about it. They just don't pay. That's not what this court's order said. And like I said, if they were doing 700 a day, in 10 days, it would have been 7,000. In 100 days, it would have been 70,000. There are only 22,000 people in this group. So they should have been done in about, 30 or 40, 50 days, whatever the math turns out. Instead, it's 4 months later. Nobody's been adjudicated anything. No one's gotten any notice. No one's got anything. And now we're just backpedaling to try to justify it. And again, nothing, they haven't shown you a UILP or UIPL that says don't pay under these circumstances, even if you started paying. They all say if someone's in another program, they're not eligible for this program. And I don't understand the quarterly reassessment if nothing's changed. What are you supposed to reassess? It's quarterly reassessment if they have earnings. They don't have any earnings, they're unemployed. So I think that's why you should issue your contempt. And if you want to make a civil contempt, give them 2 weeks to purge it. I don't care. Again, it's not the $1,000. It's getting them to reorder the priorities so they pay people. Thank you.
All right, let me start preliminarily by thanking everyone for the very spirited and professional manner in which this was presented to the court today. Indeed, as has been observed in prior hearings, this is the unique case where essentially both sides to the dispute have the same goal, which is to have people who are otherwise eligible for benefits to be promptly paid so that they can have a subsistence level of economic support during the unprecedented times of the pandemic. That being said, the court finds that the state of Nevada is in contempt of its prior order of mandate. That order was filed on July 22nd. The order was specific. In the court's estimation, it was clear. Let me repeat the operative term on page 8 going into page 9. It is hereby ordered, adjudged, and decreed that once payments have started, payments cannot be withheld and must be restarted unless one of 4 things was occurring. A, the applicant did not file a weekly claim, or B, the applicant has earnings in excess of that which would otherwise qualify the applicant for benefits, or C, there is clear and convincing evidence of fraud by the applicant, or D, until such time as the applicant is afforded an opportunity to be heard. Now, in hindsight, the court's directive of ordering the state to commence payments on or before July 28, 2020 was unrealistic. It was too soon. Obviously, with the benefit of hindsight, the court ought not to have put such a short time frame. And if the court had to do it all over again, it would have been a much longer period of time, in the neighborhood of 30 to 45 days. So for the angst or challenge that the state faced by virtue of the short time frame involved, the court apologizes. It understands now it's much more involved. Nevertheless, here we are in December, and we still have issues. Importantly, the state has not moved this court to stay enforcement of its writ of mandate. The state has not obtained an order staying enforcement from an appellate court with authority over this one. And notwithstanding that there are cross appeals, plaintiffs arguing the court's order of mandate did not go far enough, the state arguing that the court's order of mandate went too far, the fact is the court retains ancillary jurisdiction to enforce its orders. So what is the court faced with that justifies its conclusion here? Well, it's undeniable that we have incredibly worthy efforts by the state, its employees, its senior administrators, its management team, to work hard on behalf of the people who need their benefits. The court has repeatedly commented. In fact, one of its prior orders remarked that Administrator Gaw, I believe the court used the phrase or something similar, had exemplified extraordinary effort to comply and get people their benefits. It's not lost on the court that the Employment Security Division and D.E.T.R in particular have hired new people, are training new people as quickly as they can, are bringing back people who are retired, are hiring contract workers, are trying to get the benefit of prior work history, experience, and expertise, all with the singular goal of getting people paid as promptly and lawfully as they can. And the court takes that into consideration. It's also not lost on the court that there indeed appears to be, at least in the eyes of the state, a tension between this court's order of mandate and Department of Labor guidelines. And the state has important concerns that its actions need to be measured so as not to run afoul of the federal government restrictions and directives and guidelines with respect to how to administer this program. Because, as has been brought up several times, the risk is significant if they do. The state runs the risk of having funding cut off, runs the risk of having penalties imposed, runs a risk of having possibly, as the court understands, to disgorge and return some of the money. And those are serious concerns, and the court understands and appreciates that. But those were concerns made known to the court back in the summer. And the court took great pains to make sure that its order, to the best of its ability, both complied with the law, complied with Department of Labor guidelines, but again, was consistent with jurisprudence from the United States Supreme Court, at least as this court understands and has applied it to the unique circumstances here. And that's why the court fashioned its order in the measured and limited way that it did. The court has no desire to put the state of Nevada or those receiving benefits in harm's way. The court's goal is to get the state to comply with the law and provide additional payments to those whose payments have started and now stopped. So, the court heard from examples of three people that the plaintiff asked the court to take note of: Ms. Boyd, Mr. Kolznick, and Mr. Dougherty. The court has a certain level of experience in measuring people's credibility. And it seems to the court that the farthest thing from Ms. Boyd's mind would be in any way to intentionally mislead D.E.T.R or otherwise commit a fraudulent act, much less any evidence that would get close to clear and convincing evidence. As to Mr. Kolznick, with respect to his payments stopping, it's entirely clear to the court that he has done his level best to comply with everything asked of him in order to receive payments, but he is being caught up in that big bucket of people that have not been paid because the state believes the fact that they may have eligible benefits in UI or another employment assistance program. He's caught in that big net. So payments are going forward with respect to him. But in the court's estimation, he too was a very credible witness and made the case for people like him who have similarly been caught up in that unfortunate situation. And then finally, Mr. Dougherty, his was a little more difficult for the court to understand, but it seems to the court that he credibly made a case for being owed payments, the complete amount of payments until at least the time he began work again in August, if not more recently. The court, however, is not here to adjudicate the strength of their claim. I'm not acting as a hearing officer, an appeals officer. I'm just observing that if those three are representative of the types of issues and challenges that people are facing that are caught up in the 20 or 30,000 who have not yet been paid, then the court finds that those people likely would have been entitled to payment under the court's order. The court finds that the state's witnesses, Ms. Allender, first of all, the court found her very credible and a hard worker and knowledgeable and trying very, very hard every day to do the right thing. The only issue the court has with Ms. Allender's approach is she's marching to the wrong tempo in the court's estimation, because it appears to the court that she's under the impression that the court order did not require payments to be released to certain groups of people that the court finds it should have been. Mr. Markevka as well, the court found credible and appreciates his hard work now on the administrative side, not on the processing side. Mr. Bracken obviously has a wealth of information and knowledge and experience. It's to his credit that he's come back to help out the state, not apparently once, but twice when he is otherwise to be retired. He helped stand up the P.U.A. operations apparently in May, and he has now come back and is acting as an adjudicator under a contract under the UI system. Again, though, his worldview of what the state's role is and the level of effort and action to comply with the court's order is unfortunately inconsistent with this court's view of the law. But the court commends Mr. Bracken for his hard work. Mr. Schmidt, the court has heard from before and found him then and continues to find him extremely credible, extremely honest, a tremendous asset in the Research and Analysis Bureau, and is personally and judicially glad that he is on the team for the state of Nevada, because he brings a wealth of information, knowledge, and commitment. It's clear to the court. Mr. Ricketts, I'm going to not hold it against him that he was addressing the court in a hearing like this from his smartphone, and commend him for doing his best to find a place that he could connect without too much technology interference. Mr. Ricketts, though, also has quite a bit of his institutional background information and knowledge, and the court appreciates his efforts on behalf of the state, and his candor is undeniable. And then, of course, we have the director, Ms. Cafferata, who has come in fairly recently, along with Ms. Buckley, and is attempting her level best to improve the situation. And as she educated the court, it's really not her call at this time with respect to some higher level policy decisions with respect to how to approach the court's order in light of Department of Labor guidance. But nevertheless, here's where we are. The court finds that notwithstanding the special master's prior conclusion, several months ago, that the state was in substantial compliance, the court is left with the inescapable conclusion under Nevada Revised Statute 34 that the state 34-290 subsection 2, that there has been a violation of the court's writ of mandate. Now, the question is how? Is it the 8,000 or 9,000 people whose benefits are being held up because of indicia, markers, or hallmarks of fraud? The court's order was clear that it needed to be more than just a sniff of fraud. It needed to be more than just a sense, an inkling, and some indicia. It needed to be more than that. And the court, through this course of the hearing today, was on the fence with respect to the state's view and approach. But the more I learned of what is happening and what has been going on, the court is convinced that the state has complied with that portion of the court's order. The court specifically finds at this time the state is not in contempt. The part the court, however, diverges from the state's approach is with respect to people whose claims have not been paid based on the state's belief that there are available UI benefits or other employment-related benefits from within or without of Nevada. Now, I want to make something clear. The court order did not then, nor is the court today, directing the state to pay people who have UI benefits available. Court's not doing that. Court did not do that this summer. What the court did in the summer was, if you started to pay them, you cannot stop without them getting a hearing, without them having an opportunity to protest, without them having an opportunity to be heard. The court did not then and is not now enforcing that order based on its view of how things should be. It did not then, nor is it now making this determination because it believes that's the correct, right approach on how benefits should be paid under the Pandemic Unassistance Program. It has to do with the court's review, analysis, consideration, and determination of what United States Supreme Court precedent, as applied to the unique facts and circumstances of this case at this time during the pandemic, requires. Once started, payments may not be stopped. The court believes that the 9,000, give or take, people who were caught up in that net, including some people we heard from today, should have been paid. If not by July 28th, then promptly thereafter. So the court finds the state in contempt for that reason and that reason only. The court imposes a $1,000 fine on the state of Nevada. The fine shall be paid no later than 30 days from today, unless there's a stay or a court order. I am doubling down on the court's prior order of mandate. I'm directing the state today to pay those people that I've just identified no later than 3 weeks from today. That being, it's not lost on the court what day that is, December 24th. Payments need to resume by that date, unless there's a court order extending that period of time. unless there's a court order staying enforcement, unless there's an appellate court order that directs that this court cannot enforce that order. But until and unless such an order results, I'm giving the state 3 more weeks. Now, if I find, and I'm going to set a hearing for the following week, December 31st at 9 in the morning, a week after the deadline. If the court finds at that time there has been a willful failure without excuse to abide the court's order to pay that group of people or resume paying them no later than December 24th, then the court will consider additional sanctions, punishment, or enforcement mechanisms for its order. Look, this court takes no pleasure whatsoever in admonishing the state, particularly when I have time and again commented on the extraordinary effort the people of the state are taking to help those in need, especially during the challenging times, which we all read the news are getting more challenging because of the grip the pandemic has as we all await, hopefully, an effective vaccine. But it's been 4 to 5 months. These people need to be paid. The court believes its order is not in conflict with the Department of Justice guidelines. The court does not intend to put the state of Nevada in financial harm's way. The court wants to get people paid promptly. So those people the court has just identified need to start being paid again no later than 3 weeks from today. The court sets a status hearing on this matter for December 31st, 9 o'clock in the morning. That will be the order of the court. Let me start with the movement, Ms. Jones, and then I'll hear from Mr. Thierman. Is there anything the court may have overlooked at this time?
Nothing from me, Your Honor. Thank you.
Mr. Thierman.
I have nothing further except who do they make the check out to? You, the court?
The check will be made to the clerk of the court unless the court directs them otherwise.
Thank you.
You're welcome. Mr. Ott, well, let me start with Mr. Whitney. Mr. Whitney, any further questions or comments?
The only thing that concerns me, Your Honor, is how soon the $1,000 is to be paid. I don't mean to be funny, and Mr. Ott probably more knowledgeable about this because he's been kind of looking at it. The court probably remembers that. I'm just thinking we might have to go to
45. All right.
Please.
Mr. Ott, is there any issue if the court changes its directive and has the state make the payment within 45 days of today?
I would have to look at the Board of Examiners and the Interim Finance Committee schedule. I would be fine with the court making that order. If 45 days is insufficient, we could file subsequent notice to the court and let them know a subsequent time.
Thank you. It'll be 45 days from today or the nearest court day. Other than that, Mr. Whitney, anything else from the state?
No, Your Honor. Thank you.
Thank you. Mr. Ott, anything else you'd like to bring to the court's attention at this time?
One thing, Your Honor, and I don't mean to open a can of worms, so please slap me down if you feel should be addressed in a subsequent motion. But when you were listing out your ruling, you mentioned that your ruling was not intended to pay people in 2 different systems. But you also said people must continue to get paid. But there could be a situation where D.E.T.R identifies someone who's actually receiving benefits in another state or in another system. That's not technically covered under the court order currently. But and I don't know whether the court even has the ability to amend its order because it is up on review to the Supreme Court. But
well,
I feel like I need to address that.
Well, I don't think I have the ability to amend the order. Here's what I can tell you. Mr. Thierman and Ms. Jones have argued repeatedly, particularly in early stages of this case, that people need to either get paid under the P.U.A. system or the U.I. system. And, if there's money in U.I., they need to get paid there. And if there's not, they need to get paid with P.U.A. But at this point, the court's order is simply that people need to get paid under the P.U.A. system if they've begun and were stopped. Now, if you're saying, well, what do we do if if they're already receiving money under UI? Or what do we do if And the answer to that is, I'm not going to take that up right now. If you have evidence that that's occurring, and the court should consider how to approach that. But right now, I'm not sure the court order on the writ of mandate, the order of mandate is the type of thing that is amendable, but I would look into it if the facts bear that out, and I'll see what the court's jurisdiction is at that time.
Thank you, Your Honor. If it's necessary, we'll address in subsequent motion work.
Okay, but do it fast, because
if they really do have a check going two places, I wouldn't consider that. I wouldn't bring the contempt. We'll put it that way.
one more, say that again, Mr.
I
Thierman.
said, if they really have a check from another or proof of actual payment from another program, I would not bring a contempt. I would not bring that as a contemptible act.
In other words, if they're getting paid there, that's good enough.
I only want them to get paid once. That's the whole point of this. But once and only once.
All right. Well, Mr. Ott, I mean, we're not going to spend more time on that right now. I understand the concern. If that issue ripens and you want to bring it to the court's attention, please do so. We can even do it on short notice. So we can talk about it on we can talk about it on December 31st at 9:00 in the morning, if that has ripened into a dispute. But you've just heard Mr. Thierman identify, at least preliminarily, that if you come back on the 31st and it appears that people are being paid as ordered by the court, other than those that are receiving UI benefits, because that was the essence of what the plaintiffs sought here, then the plaintiffs will likely not ask the court to find the state is in continuing violation of the court order. All right. With that will conclude this hearing. I want to thank everybody and ask to you and your families a safe holiday. And the court will be in recess. I'll see everyone next December 31st at 9 a.m. Thank you very much, everyone.